Now, turning to the debate itself, there are three broad areas I'd like to cover: sovereignty, costs, and some of the scariest parts of the bill. And I must admit, listening to the member from Kenilworth and Southern, I am not nearly as learned or experienced as him and bow to his legal analysis, for I'm a mere doctor, so I look for evidence-based and trying to understand a little bit of the process about it. And to that end, I thought it'd be quite useful to write to the Foreign Commonwealth and Development Office, which I duly did, and received a letter on the 28th of July 2025 from the Minister for State for Europe, North America and UK Overseas Territory, who I see has kindly responded and is sat in his place. And much to my surprise and much to my pleasure is actually a lot of what has been written in the letter was formed part of the new minister's speech when he came to the dispatch box. So it allows me to walk through some of this letter and pose some of the questions that have hit me when I've looked into this case. Because I must admit, stepping into this House back in 2019, this was not a topic that I knew a huge deal about. And I think many on these benches on both sides will say that, but very quickly became one, when it deals into security, that one should look into to understand. So in that letter, it states, we had to act now because the base was under threat. Well, that implies urgency, but it's loose on for whom, for where, and how. There is legal uncertainty, but as we've heard, we don't know which court or why. It goes on to say, the courts have already made decisions which undermine our position. Courts, plural. Now, we know the ICJ is there, but as it's been stated, it was non-binding, and there's a carve-out from the Commonwealth aspect as well. Now, the Defence Secretary, when he spoke in this debate, after being pushed multiple times, turned around and said, well, the International Tribunal for the Law of the Sea, UNCLOS, was the one of concern. But he will know that the Tribunal's award in Annex 7 back in 2015 agreed with the UK that sovereignty cannot be determined by UNCLOS. And this was all over a marine protection issue. Britons were trying to protect the area, and Mauritius wanted to open it up to be able to farm, and we were found against on that treaty, in that cause. So it bodes the question at this point in time, and it's a side but very important one, what protections are in this bill about the environment, because it seems scant and not there. Reading into the letter and going on further, it states, in 2021, a special chamber of UNCLOS suggested that sovereignty was inferred in the ICJ. So I have it from the government itself pointing out that case. It also goes on to say the UK was not party to this case. Well, obviously it wouldn't be. But that means we haven't had our day in court to explain why we don't think it should apply in the first place. And it was inferred from the non-binding political judgment that we've already heard about and talked about. The letter goes on, if Mauritius were to take us to court again, the UK's long-standing legal view is that we would not have a realistic prospect of successfully defending its legal position on sovereignty in such litigations. Well, which court? And if it's so long-standing with this advice, why don't we know about it? How have we got this far in the first place to go for years upon years upon years with no agreement, without any urgency? It therefore seems sensible and appropriate to release the advice on this particular aspect. And at the start of the letter, it said, if Mauritius. The letter states later on, highly likely that further wide-ranging litigation will be brought quickly by Mauritius against the UK. So what evidence does the government have to back that up? What evidence does it say it's going to act so quickly? Because we certainly haven't seen this. If this was from 2021, we're now into 2023, 2024 dates have been said, we're now in 2025. I'd be interested to see if the government would release the evidence based on how quickly this will come forward. Because the government rightly points out there have been 11 rounds of negotiations. Now, if there's 11 rounds of negotiation, there's clearly time to sort things out. And before someone jumps in and says, well, you open negotiations, we did for the Falkland Islands as well. And I find it amazing that we have trade unionists who build their whole careers about negotiating, suddenly chastising this side for listening to the other side of a disagreement. That seems bizarre to me, because the whole idea is we want to respect each other, exchange ideas, but not have an agreement. And as has been rightly pointed out on this side, the agreement wasn't there, so we didn't take it. When it comes to the cost of the deal, there is no cost because we didn't have a deal to sign off. Now, in the very next sentence in the letter, it says, This might, for example, include further arbitral proceedings against the UK under Annex 7 of UNCLOS. A judgment from such a tribunal would be legally binding on the UK. It's true on the legally binding aspect within the area they come for, but they don't cover sovereignty, as we learnt in 2015 when they said and sided with the British government. So here we have this farcical situation of a House of Policy and Law shining light reflecting back to one side and another, never actually shining on the truth. And this is where my honourable learned friend is exactly right. If the government was to come forward here and say exactly which court, where and why, they might get more sympathy on this side. But we've been through an entire 5-hour debate and we still don't have answers to those questions. Another court that's often cited is the International Telecommunications Union, covering spectrum radio and radar. Now, Article 48.1 states, member states retain their entire freedom with regard to military radio installations. And the government know this. Even in their answer, and it's been hinted at before, a written answer, it states, and I quote from the Minister, individual countries have the sovereign right to manage and use the radio spectrum within their borders by the way they wish, subject to not causing interference with other countries. This right is recognised in radio regulations. The radio regulations are the international framework for the use of spectrum by radio communication services, defined and managed by the ITU. Individual countries, not the ITU, make their own sovereign spectrum assignments in accordance with radio regulations. The ITU has no legal authority over these assignments, regardless of the country's civilian or military classification of spectrum. The ITU cannot challenge the UK's use of civilian or military spectrum. So it is clear here, the government know it in their own answers, the ITU has no role in sovereignty. So this all boils down to where you believe British overseas territories stand. Now we must talk about the costs, and they've been much debated. There are three figures in this debate: 3.4 billion, 10 billion and 34 billion. Now the 3.4 billion is the net present value using social time preference rate. The 10 billion is inflation adjusted, and the 34 billion is the nominal value by the government's actuary department. So the question is, why use net present value? I put it earlier in the debate, there is no other precedent in the world for NPV being used in sovereignty matters. The minister at the time asked why this side has not, does it want to do away with using NPV? Of course not. It's within the Green Book, absolutely, the minister is saying from within the Green Book, absolutely not, because it has a perfect place in domestic use for commercial practicalities, not for international sovereignty issues. No other country has looked at this, no other country would look at this because it doesn't make sense. And the House of Commons Library, when you asked them, said this methodology is regularly used in government accounting, but it's mainly used for cost-benefit analysis. It's unusual to see it used in this situation like this, where only the cost is being assessed and not being compared to any benefit. So on that basis, and listening to the House of Commons Library, what cost-benefit analysis has actually been done in this case, and would it be put in front of the House so we might well be able to see it? Because at the end of the day, NPV is highly political because it assumes a discount rate. And what is the discount rate that you should choose? In the details, it talks about 3.5%. But the US will use 3.5% or 7%, which vastly differentiate the figures. And it goes on further. For the social time preference rate is 3.5%, but for 30 years. This deal is for 99 years. So how can the government respond in a written parliamentary question that this, I quote, represents good value for UK taxpayers? On what basis are they comparing that if there's no international comparison? We're only talking about domestic uses and it for an accounting point. But as I come to my conclusions, possibly the scariest thing to me, and I've tried to highlight it through this debate, which does seem to be falling on deaf ears, is Article 13. Because I believe this treaty is legally bomb-proof. It looks very sensible, and I'm no legal expert as I've attested to, but it seems to stand the test of time. Which means when Article 13 is explicit in saying that in 99 years, Mauritius can say no and just take control. That is a big worry. Now, we've heard from many benches, the benches opposite, from many MPs, how it secures the long-term aspirations of this country for a period of 99 years. And when I mentioned that, several scoffed on the other side. But isn't the duty of this House to provide for not only for the next generation, but the rest of time for our country, in the best interests of our country? So the very fact that Mauritius could pull that base, listening to all the arguments that have been made how essential it is a very scary prospect. There is, of course, a caveat, the right of first refusal. But if China decide to do a deal with Mauritius and make it exorbitant cost, we are over a barrel as the British taxpayers yet again to fork out to try and secure our security. Mauritius have been given a golden ticket in the future, and they know it. Madam Deputy Chair, to me, when it takes the sovereignty, the costs, my biggest concern is that we are outsourcing our decision-making for our children and our children's children. Now, this is the modus operandi of this government. You only have to look at the borrowing in the budget to see how they borrow on the backs of the children in our future. Pushing this decision out for 99 years is not security for now. It'll help, but actually it creates a far bigger problem in 100 years' time. And if the government wants to give away our islands, it should be open and transparent about how, why. But the biggest thing is, we haven't even had our day in court. That's what catches people the most in the British public. I think the British public would be reasonable if a court was found against us. They would happily say we follow the rule of law. But this government hasn't even tried that, won't even try that, and says that there's a risk. But as we've been talking, this has been going on for years, and still we are looking at a treaty to sign it off. This does bode final questions about what happens with Gibraltar, Falklands and Cyprus. It inevitably does. Now, the Minister is correct to point out why there are differences, but the biggest fundamental problem they have in arguing this, in arguing to the British people and the people of Falklands, is exactly trying to understand, because if this House can't understand the legal concepts and the places where we're likely to fight the courses, how do we expect the public to do so? That is a question when it comes to delivering the comms around this that the UK public need to understand.